Today, April 5th, 2026, the ruling that struck down Washington, D.C.'s magazine ban remains in effect, and the effort to reverse it has now expanded on two fronts. 18 state attorneys general have filed a joint amicus brief asking the D.C. Court of Appeals to rehear the case on bank and overturn the panel decision. A coalition of gun violence prevention organizations has filed a separate amicus brief making the same request. Both filings arrived after the court itself refused to freeze the ruling's legal force while the en banc process moves forward. If you've been following Thomas updates through March, you already know the foundation of this case. I covered the original Benson ruling, D.C.'s emergency response, and how the decision immediately spilled into the Duncan and Cheeseman cases across multiple videos. Those breakdowns are on the channel for anyone who wants the full background. What this video covers is the new wave of opposition that landed over the past 10 days, what the arguments actually say, and what the court's procedural decisions signal about the status of the ruling. On March 23rd, the D.C. Court of Appeals issued two orders. It denied D.C.'s emergency motion to suspend the precedential status of the Benson opinion, and it denied D.C.'s motion to expedite consideration of the en banc petition. The March 5th ruling, the one declaring that magazines holding more than 10 rounds are constitutionally protected, remains binding precedent in the District of Columbia. The court did not strip it of that status, and it did not accelerate the rehearing timeline as the district requested. On that same date, the court also directed Tyree Benson to file a response to the en banc petition within 14 days, placing the deadline around April 6th. The United States was invited, though not required, to respond as well. 2 days later, on March 25th, both the 18-state coalition and the gun violence prevention group submitted their amicus filings. The court formally granted the gun violence prevention group's motion to file on April 2nd. The state's brief was filed directly on March 25th. As of today, the en banc petition has organized outside support from across the country. The states filing jointly are New Jersey, Massachusetts, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maryland, Michigan, Minnesota, Nevada, New York, Oregon, Rhode Island, Vermont, Virginia, and Washington. Many of them maintain their own magazine restrictions, and their interest in this case is direct. If the Benson ruling's reasoning gains traction in other courts, it threatens the laws on their own books. Their brief argues that every federal circuit court to evaluate magazine restrictions after Bruin has upheld them. They cite decisions from the 1st, 2nd, 4th, 7th, and 9th circuits, all reaching the same conclusion. The states frame Benson as a lone departure from that consensus, not a new direction. They go further, noting that even within Washington, D.C. itself, the federal D.C. Circuit, a separate and higher court from the D.C. Court of Appeals that issued the Benson decision, previously upheld D.C.'s magazine law in Hansen v. District of Columbia. Their position is that this panel created a conflict not just nationally, but internally within the district's own court system. On the legal substance, the states challenged the common use framework that the Benson panel relied on. The panel held that magazines over 10 rounds are in ubiquitous use and therefore constitutionally protected. The states argue that is the wrong test. Their position is that the Second Amendment protects items in common use specifically for self-defense, not items that are merely widely owned. They draw a line between commercial popularity and the kind of self-defense purpose the Second Amendment was designed to protect, and they note that the average self-defense encounter involves roughly 2 shots fired, nowhere near the capacity a magazine ban restricts. They also raise what they describe as a logical problem with the panel's approach. If widespread ownership alone is enough to trigger constitutional protection, they argue, that framework could eventually extend to machine guns and bump stocks, items that exist in significant numbers, but that courts and legislatures have long treated as subject to regulation. They cite ATF data indicating more than 230,000 registered transferable machine guns as of mid-2025 and bump stock estimates exceeding 500,000 units. The states argue a pure numbers test creates what they call an arms race between manufacturers pushing products into the market and legislatures trying to regulate them, something they say has no grounding in historical analysis. The states also rely on what they consider a strong historical tradition of restricting widely used weapons after those weapons became associated with public harm. They point to Bowie knife regulations from the 19th century and slungshot prohibitions, arguing both were popular weapons that states nonetheless restricted once their role in violence became clear. Their position is that this tradition of regulating items after they enter widespread circulation, not before, directly supports DC's authority to restrict magazines. If you want to stay current on every filing in this case and the connected cases across the country, subscribing to Thomas Updates is the simplest way to make sure you don't miss any of it. The gun violence prevention groups filed separately, and while many of their arguments overlap with the state's brief, the docket identifies their filing under the label Amicus Curiae Gun Violence Prevention Groups. Their motion was filed on March 25th and formally granted on April 2nd. Based on the docket description and public reporting, these groups support DC's en banc petition and advance many of the same themes: that the panel's reasoning is flawed, that the common use analysis creates problematic precedent, and that the ruling's impact reaches well beyond the District of Columbia. Between the two filings, the opposition to Benson's continued force is now organized across state governments and national advocacy organizations. That level of coordinated response reflects how seriously both groups view this ruling, not as a local DC outcome, but as a decision with the potential to reshape the legal landscape around magazine restrictions nationwide. This connects directly to what Thomas Updates has already been covering. I broke down how the Benson ruling was cited in Duncan v. Bonta at the U.S. Supreme Court and how California responded by telling the justices Benson was not final. I also covered how New Jersey attacked the Benson ruling inside the Third Circuit's Cheeseman case. If you want the full breakdown on either of those, the previous videos have the detail. What this update adds is the next layer: the court's refusal to freeze the ruling, the formal en banc petition, and the outside parties now stacking up on both sides. What has not changed is equally relevant. The Benson ruling has not been reversed. It has not been vacated. The en banc petition is pending, not granted. The court has not announced whether it will take the case en banc. The ruling remains binding precedent in D.C. as of tonight. At the same time, the ruling does not create any nationwide standard. It is one appellate court's decision, and other jurisdictions are not bound by it. The question is whether it influences them, and that influence is exactly what these filings are designed to counter. Looking ahead, and this is analysis based on the current posture, not a prediction, the next procedural step is the response to the en banc petition due around April 6th. After that, the full court will decide whether to grant rehearing. If the court takes the case en banc, the panel ruling would typically be vacated while the full court considers the issue fresh. If the court declines en banc review, the ruling stands, and the next move would likely be a petition to the U.S. Supreme Court, though which side files first could depend on how other cases, particularly Duncan, are handled. The broader picture is one of escalation. One court's ruling has produced filings in at least 3 other cases, drawn responses from 18 state attorneys general, prompted an amicus brief from national advocacy organizations and created a direct tension between the D.C. Court of Appeals and the federal D.C. Circuit. Whether the full court steps in to rehear the case or lets the panel decision stand, Benson has already become one of the most consequential magazine-related rulings since Bruin. Thomas Updates will continue tracking this case and every connected proceeding. When the response to the en banc petition lands or when the court announces its decision on rehearing, the update will be here. If you haven't subscribed yet, now is a good time. The next few weeks could determine whether this ruling keeps building momentum or gets pulled back. Everything covered in this video is drawn from publicly available court docket records, published judicial filings, official press releases from state attorneys general, and public reporting. This reflects my analysis of those materials, meant to inform rather than advise. If any of these legal developments touch a situation you're personally dealing with, the right call is to speak with a licensed attorney in your jurisdiction.